Good afternoon, everyone. My name is John Jurrians. I'm the director of the Whitlam Institute. Welcome to our second annual CPD series, examining the contemporary relevance of the transformational legal reforms established by the Whitlam Government. I wish to acknowledge and thank Norton Rose Fulbright for generously sponsoring this event. The Whitlam Institute is a non-partisan research and policy think tank, Prime Ministerial Archive, and public museum, dedicated to excellence in its delivery of distinctive, bold, inspiring research, policy, and programming. We promote common ground, inclusive national identity, and democratic engagement for all Australians. We seek to be recognized across the political spectrum as delivering, in Goff's words, a nation-building agenda to promote equality, to involve the people of Australia in the decision-making processes of our land, and to liberate the talents and uplift the horizons of the Australian people. Today, our speakers will investigate legislation to establish a new system of federal administrative review that would abolish the AAT and establish a new fit-for-purpose federal administrative review body to be named the Administrative Review Tribunal. Now, before I hand over to John Faulkner to introduce our speakers, I wish to make a few preliminary announcements. I thank Professor Matthew Groves and Professor Greg Weeks, co-editors of the Australian Journal for Administrative Law, who will produce a special issue incorporating contributions generated by this CPD. Now, an elder from the Wurundjeri Land Council was unavoidably delayed, but I am pleased to have the opportunity to offer an acknowledgement of country. The Whitlam Institute strongly supports Indigenous peoples having meaningful input into the decisions that affect their lives and their futures. Half a century ago, in his 1972 Labour Party policy speech, Gough Whitlam said, "There is one group of Australians who have been denied their basic rights to the pursuit of happiness, to liberty, and indeed to life itself for 180 years. Since the very time when Europeans in the New World had proclaimed those rights as inalienable for all mankind." Gough Whitlam was right 50 years ago. His words continue to resonate today. The Whitlam Institute recognizes this historical reality and acknowledges the need for Aboriginal and Torres Strait Islander peoples and their voices to be heard and heeded. We recognize the traditional custodians of the lands on which we work, pay our respects to elders past and present, and stand in strong support of the cause of Aboriginal and Torres Strait Islander peoples' justice and empowerment. Once again, thank you for your attendance. I call upon the Honourable John Faulkner to introduce our speakers.
Well, thank you, John, and thank you all for joining us. I very much want to warmly welcome you to this afternoon's seminar. I'd like to begin by just placing on record our sincere appreciation to Her Honour, Chief Justice Deborah Mortimer, and all those from the Federal Court and the Administrative Appeals Tribunal who've assisted us in hosting this seminar here today. As part of our Whitlam Government 50th anniversary activities, the Institute has organised a series of legal seminars commemorating aspects of the law reform achievements of the Whitlam Government. We held the first of our seminars in Sydney last year on the issues of legal aid and equality before the law. This is our second seminar today. As you know, it's entitled A New System of Federal Administrative Review. Later this year, in Canberra, we're holding another seminar to explore the significant legislative changes brought about by the 1974 double dissolution election and then the joint sitting that followed. And Also next year, then we'll deal with the rather complex legal issues relating to the 1975 constitutional crisis. In addition to those formal speakers that you'll be hearing from in a moment, I'd like to acknowledge that we're joined today by Justice Michael Lee and ABC Chair Kim Williams, both of whom serve on the Whitlam Institute board. And of course, our board has a grand tradition of very broad representation in the community and across the political spectrum. And this is very unique for a prime ministerial institute, as you know. Well, ladies and gentlemen, we're very fortunate to have a remarkable lineup of distinguished speakers today. We'll hear shortly from both the President and Deputy President of the Administrative Appeals Tribunal. And can I say to your honours that we are sincerely grateful that you've joined us today and privileged that you'll be addressing us. A little later, as you've heard, we'll have a panel discussion led by two of the nation's leading silks, Ruth Higgins SC and Tom Brennan SC. But first, we will hear from the Attorney General. Ladies and gentlemen, last year I also had the opportunity of introducing the Attorney General. I didn't make a long introduction. I can assure you it wasn't Whitlam-esque in length. I know I said words to the effect that in my years in the Federal Parliament, I served with no one of greater integrity than Mark Dreyfus, and I simply can't give higher praise than those words, and they do bear repeating. I know that I believe that Mark deserves great credit for his drive and advocacy in establishing the National Anti-Corruption Commission, and I believe for his vision in overhauling the administrative review system in Australia. Mark, I thank you very, very much, very sincerely, for joining us today. And I ask you, ladies and gentlemen, to please welcome the Attorney General.
Good afternoon, and thank you very much, John, for the non-Whitlam-esque but still over-effusive welcome. Can I acknowledge the traditional owners of the lands on which we meet today, the Wurundjeri Woi-wurrung and Bunurong Boonwurrung peoples of the Kulin Nation. I pay my respects to their elders past and present. I extend that respect to any Aboriginal and Torres Strait Islander person here today and to those who are joining us from other locations. Thanks very much, Professor John Jurians and the Whitlam Institute for the invitation to speak to you today. I came last year, must have done okay because I've been invited back. And I would like to acknowledge John Faulkner, both for his warm welcome and expert introduction and for his long and distinguished service to the Parliament and the nation. It was a privilege to serve in the Parliament with John. It's always terrific to catch up with him, especially at events that reflect his continuing passion for integrity, ethics and law reform. And I do thank the Whitlam Institute, the Western Sydney University and our host this year, the Federal Court of Australia, for organising this second event in what I hope will be a long-running series. Joining us today are many distinguished guests and speakers, including the President of the Administrative Appeals Tribunal and Judge of the Federal Court of Australia, the Honourable Justice Emilios Kyrou, to my left, and the Deputy President of the Administrative Appeals Tribunal and Judge of the Federal Court of Australia, the Honourable Justice Lisa Hespe, Tom Brennan SC and Ruth Higgins SC. And I'm pleased to acknowledge the presence of members of the Administrative Review Task Force in the Attorney General's Department. Members of this task force, alongside other Commonwealth officials, have worked long and carefully on the development of the new Administrative Review Tribunal, and I'm grateful for their efforts. 12 months ago, I was honoured to give the keynote address at this seminar, and last year I began my address by acknowledging the important legacy of the Whitlam Government in its reform of the legal assistance sector. Today I'll again recall the Whitlam Government and its establishment of a federal system of merits review of administrative decisions. In the early 1970s, the Commonwealth Government was exercising more discretionary authority over the community and business. The post-war era had seen governments provide new forms of social welfare support, and it had been a period of greater investment in community grants, in education, in healthcare and other social measures. All of these developments resulted in more people being affected by government decisions, including as individuals. At the time, the only avenues available to challenge these decisions would have been to seek an internal review, if that was available, from the particular department concerned, or to apply to a court for judicial review. This was not available or accessible to many people. Greater interaction between the community and government gave rise to greater community expectations of government agencies and public servants. In particular, there was an insistence that governments and public servants act lawfully and in the public interest, and in a manner that is responsive, transparent and answerable. This holds true today, and rightly so. The architecture of a new system of merits review was mapped out by the final reports of the Commonwealth Administrative Review Committee, known as the Kyrou Committee, in 1971, and the Committee on Administrative Discretions, the Bland Committee, in 1973. These reports inspired landmark legislation. The Administrative Appeals Tribunal Act 1975 was enacted, establishing the AAT and creating a new federal system of merits review. The new system of merits review was not confined to questions of legality, notwithstanding the fact these are questions of paramount importance. The new system of merits review sought to arrive at the preferable decision. The AAT Act also established the Administrative Review Council, or the ARC, which was tasked with advising the government on all matters of administrative law. These significant reforms occurred alongside the establishment of the Federal Court of Australia and the commencement of the Administrative Decisions Judicial Review Act 1975, which codified common law grounds of judicial review and imposed for the first time a comprehensive statutory obligation upon administrative decision makers to provide written reasons for their decisions. The value of merits review is well reflected in the 2013 comments of Justice Duncan Kyrou, who served as President of the AAT from 2012 to 2017. And I quote, "Once rare, merits review has become an entrenched part of the Australian legal system. It is more frequently accessed than is judicial review. Courts deal with thousands, perhaps even tens of thousands of applications for judicial review each year, but merits review tribunals deal with hundreds of thousands of applications in the same period." In a democratic society, the system of review of administrative decisions must operate to ensure governments and public servants are accountable to the community, especially when unfairness or illegality is present. Everyone in this room is aware of the robo-debt scandal. In this case, governments and public servants were not held accountable, or maybe better put, were not held accountable soon enough. The merits review system repeatedly found against robo-debt, but those findings were ignored. The Royal Commission, which reported last year, found, and I quote, "The beginning of 2017 was the point at which robo-debt's unfairness, probable illegality and cruelty became apparent," unquote. but the scheme continued for a further 3.5 years. The human tragedy caused by the illegal robo-debt scheme must never happen again. Part of making sure it never happens again is a strengthened merits review system. The current Labor government came to office committed to taking measures to restore integrity and accountability in government and support our public institutions. Improving access to justice and strengthening our system of administrative review is a key feature of this work. Half a century after Whitlam's reforms, we are rebuilding our merits review system. Administrative review is an essential part of the Australian legal framework. It promotes the rights and interests of individuals who are the subject of government decisions and upholds transparency and integrity in government. The Albanese government has committed to the most significant reform of the administrative review system since the Whitlam era. We've introduced legislation to establish a new body, the Administrative Review Tribunal, that is designed to be independent, accessible and fair. At the same time, we are investing in the Australian Public Service and re-establishing the Administrative Review Council to improve the quality of administrative decision-making from the outset. The situation that the AAT finds itself in today did not occur overnight. For years, we witnessed the erosion of the AAT and a loss of public trust and confidence in the system. More recently, the public has become aware of the appointment of politically affiliated individuals to the AAT without any transparent or merit-based process. This undermined the independence of the AAT and further eroded the quality and timeliness of its decision-making. To further exacerbate the situation, the AAT was unable to process the number of applications lodged with it and left it with an accumulating backlog of cases. The end result is that some individuals seeking review of a decision are waiting 10 years or more for a final outcome. This is plainly unacceptable. The changes we are making go far beyond changing the name of the tribunal. We are entrenching merit-based appointment processes. These processes mean that every citizen who makes an application for merits review will know that the tribunal member dealing with their matter was appointed on merit. It's a simple thing, but it's very important. The tribunal will feature a guidance and appeals panel that will have a formal role in providing guidance on significant systemic issues arising from government decision-making. This is aimed at ensuring that errors in administrative decision-making or indeed illegality, as was the case in robo-debt, are not perpetuated. In addition, for the first time, tribunal decisions that raise significant issues of Commonwealth law or policy will be required to be published. This increased transparency will promote accountability in government and the public service. The President will have a central role, supported by the entire leadership team, in ensuring the tribunal meets the new limb of its objective to improve the transparency and quality of government decision-making. I'm delighted that Justice Kyrou will be the inaugural President of the Administrative Review Tribunal. He brings exceptional knowledge of administrative law and outstanding leadership to this challenging and hugely important role, and I acknowledge Justice Kyrou for his leadership of the AAT. I'm grateful to him for the work he has done alongside the Registrar, Michael Hawkins, in ensuring the AAT functions effectively in the quite unusual environment in which it finds itself. I also thank Deputy Presidents, members and staff of the Tribunal for their work. As I've noted, inadequate resourcing has been a drag on the system of administrative review to the detriment of the AAT and individuals seeking merits review. A demonstration of the government's commitment to merits review can be seen in the 115 new appointments to the tribunal we've made since coming to office. It's not just additional resources we've delivered to the system. Each new member appointed by this government has been appointed through a transparent, merit-based process. Legislation establishing the new Administrative Review Tribunal has been before Parliament since last year. It's time we got on with it. If passed, the legislation will go a long way towards restoring public trust and confidence in Australia's system of administrative review. It will establish a new tribunal that is fair and just, must ensure proceedings are accessible for all parties, and must have regard to the circumstances of each proceeding when exercising its discretion in a review. The legislation gives the new tribunal a range of powers to resolve applications in a timely, informal and inexpensive manner. It enables procedures to be harmonised across jurisdictions, requires decision makers to participate, and enables alternative dispute resolution measures to be used so that matters can be resolved without a hearing and with the least formality possible where appropriate. The tribunal will be accessible and will protect the rights and interests of individuals. This will include providing culturally appropriate, safe and supported access to justice and a more accessible tribunal, including for people with disability. The re-established Administrative Review Council will be tasked with inquiring into systemic challenges in administrative law, monitoring the performance of the federal administrative review system, and supporting education and training for Commonwealth officials. I believe this new tribunal and the re-established council will help restore public trust and confidence in Australia's system of administrative review to the level it enjoyed following the administrative law reforms of the Whitlam era. And while it will take perhaps a long time before the pain caused by robo-debt to fade and it becomes a permanent cautionary tale in our collective memory, the steps we take now will ensure that a catastrophic failure of such magnitude can never happen again. Administrative law and merits review allow those affected by government decisions to seek review on matters that have a significant impact on their day-to-day lives. It should mitigate against inappropriate decision-making. Merits review is an important part of open and transparent government and holds governments and public servants to account. I can think of no more authoritative voice on administrative law and merits review in Australia than the inaugural President of the AAT and later Chief Justice of the High Court of Australia, Sir Gerard Brennan. In 1996, while Chief Justice, Sir Gerard observed this: "Effective merits review is an essential part of the legal framework that protects the rights and interests of individuals. It also promotes government accountability and plays a broader important role in improving the quality and consistency of government decisions." I couldn't agree more. The Australian people deserve a system of administrative review that delivers high quality and accessible review of government decisions for all users, and one they can trust. I hope that Parliament gives Australians what they deserve by supporting the government's reforms. These changes are too important to be held hostage to mindless partisanship or performative grandstanding. Thank you once again to the Whitlam Institute for the invitation to speak to you today, and I thank all of you for your interest and attention. Thank you very much.
Good afternoon. If you say AAT and ART quickly, they sound almost the same, don't they? However, it would be a mistake, as the Attorney has said, to regard the Administrative Review Tribunal, the ART, as a mere rebranding of the Administrative Appeals Tribunal, the AAT. In fact, there are fundamental differences between them. They are too many for me to mention this afternoon, but I'll focus on 4 features of the ART which provide a greater measure of structural and operational flexibility than the AAT currently does. If I were to summarise the overall effect of the changes, I would say that they will enable the ART to operate on a truly national uniform basis and to be more agile than the AAT is. The 4 features that I will focus on are firstly jurisdictional areas, lists and assignments of members. Secondly, conferral of significant powers on registrars. Thirdly, the guidance and appeals panel that the attorney has mentioned. I'll use the acronym GAP. Not sure how suitable that is, but GAP it is. And finally, flexibility in managing individual cases. Now, for ease of reference, I will assume that the 3 bills currently before the Parliament will be passed in their current form, and I'll refer to their various clauses as sections, as if they were acts. Turning to the first of the matters, jurisdictional areas, lists and assignment of members, these are amongst the most significant structural reforms in the new legislation, if passed. They will replace the current divisional structure, of the AAT in favour of groupings of cases in what are called jurisdictional areas and lists sitting under those jurisdictional areas. The AAT at present has 8 divisions. They are the General Division, Migration and Refugee Division, the National Disability Insurance Scheme Division, the Security Division, the Social Services and Child Support Division, the Taxation and Commercial Division, the Small Business Taxation Division, the Freedom of Information Division, and finally the Veterans Appeals Division. Some of these divisions hear matters which have always been heard and determined in the AAT. Others were added following the introduction of new Commonwealth government schemes, such as the NDIS. Others were added to the AAT's original jurisdiction following amalgamation of the AAT with the Migration Review Tribunal, or MRT, the Refugee Review Tribunal, the IRT. There's lots of acronyms in this area. And finally, the Social Security Appeals Tribunal, the SSAT, in 2015. The Migration and Refugee Division has largely the same jurisdiction as the old MRT and RRT. The Social Services and Child Support Division of the AAT largely has the same jurisdiction as the old SSAT. So these were essentially grafted on to each other as part of the amalgamation in 2015. And that's been part of the issue that we've grappled with ever since, that they've continued to operate in some respects as separate silos under the umbrella of a common AAT name. By contrast, Section 196, subsection 1 of the ART Act establishes 8 jurisdictional areas. They are the general, secondly, the intelligence and security, thirdly, migration, fourthly, National Disability Insurance Scheme, fifthly, protection, sixthly, social security, seventhly, taxation and business, and finally, the veterans and compensation and workers' compensation jurisdictional area. So these jurisdictional areas are largely groupings of similar case types under a jurisdictional area banner. One of the most significant changes, of course, is the separation of protection or refugee cases from migration cases. So they are now part of separate jurisdictional areas. The Attorney General can appoint a Deputy President as a jurisdictional area leader for one or more jurisdictional area. So jurisdictional area leaders replace the current division heads of the current divisions. A key change in the ART Act is the conferral upon the President the power under Section 196, subsection 2, to establish one or more lists as sub-areas within a jurisdictional area. So lists sit under jurisdictional areas and separate out the different types of cases that fit within a particular jurisdictional area. Such lists do not exist at present in the AAT. The concept of lists is well known to some state and territory civil and administrative tribunals. Section 198 subsection 1 of the ART Act empowers the President to assign a Deputy President or a senior member to lead one or more lists. Section 196 subsection 4 provides that the President may determine the jurisdictional area or list within which the tribunal's powers are exercised. So it is the President who decides which jurisdictional areas cases will be heard in. Section 199 subsection 3 provides that the President may assign members other than the President or Deputy Presidents to one or more jurisdictional areas. The President and Deputy Presidents sit across all the jurisdictional areas. They're not assigned to any particular jurisdictional area. The President's power to create lists and to decide the lists in which cases before the ART will be heard and which members can hear which types of cases in which list represent fundamental changes to the present position. Essentially, it shifts control of the organisation of the Tribunal's jurisdiction from the Attorney-General to the President. The Tribunal itself, led by the President, as advised by the Tribunal Advisory Committee, basically determines how best the Tribunal's resources are organised to meet its statutory objective. Currently, legislation requires that certain matters be heard in particular divisions. So there's no discretion about that. It's mandated by legislation. And in some cases, there are special procedures that need to be followed in particular divisions. So there are statutory provisions which determine that some of the procedures are different as between divisions, which, as I said before, perpetuates some of the silos that were in existence before these three major tribunals were amalgamated in 2015. For some divisions, the Attorney-General must consult the Minister administering legislation falling within those divisions before assigning members to those divisions. These arrangements result in some inflexibility and delay and have contributed to the AT's inability to operate as a fully unified national body. Some of the feedback that the Attorney-General's Department received during the consultation process for the ART was to the effect that in some respects the ART operates in silos due to the structures that were introduced as part of the 2015 amalgamation. That's the point that I made earlier. It's actually been reflected in a lot of the feedback that the government received as part of the consultation process. These arrangements do not always facilitate the flexible and quick movement of members between divisions in response to changes in caseloads and surges in particular cases in particular areas. The ART Act provides an opportunity to move away from the historical silos and to establish a national tribunal in which processes are as uniform as possible, cases are allocated to jurisdictional areas on a functional basis, and members are allocated cases flexibly to meet the changing operational needs of the tribunal. The President will now have the flexibility to rearrange the ART's caseloads into groupings with similar subject matters, procedures and member skills, in contrast to the current system where historical and other reasons determine which divisions matters are heard in. The President can also alter these arrangements in response to changes in volumes of caseloads and legislation, or, importantly, to provide greater flexibility and diversity in the work that members perform. They're not stuck in a particular silo for the entirety of their term. As part of the planning for the transition for the ART, which I can say has been in full swing since about October last year, and we're eagerly awaiting what happens in Parliament. As part of that process, I have been giving careful consideration to the lists to be created and the cases to be allocated to each list. For example, at present, some decisions made under the Migration Act are heard in the Migration and Refugee Division, whereas others are heard in the General Division. I am examining whether some matters presently heard in the General Division should more appropriately be heard in a list set up in the migration jurisdictional area. By way of further contrast, or example I should say, for historical reasons, child support cases are heard together with social security cases in the social services and child support division. They are entirely different types of cases. Social security cases are dealt with in an inquisitorial basis where the department is not there, whereas child support cases involve adversarial parties and adversarial processes apply. Also, many child support matters involve complex financial statements, tax returns and trust deeds, which are obviously not present for someone seeking a disability support pension or similar benefits. However, presently few members from, for example, the Taxation and Commercial Division who have expertise in analysing tax returns, trust deeds and other financial documents are cross-assigned to the Social Services and Child Support Division to hear complex child support matters. So the new legislation provides an opportunity to have a fresh look of where matters are heard and what the rationale is for them being in a particular area, and to create lists which organises the hearing of cases on a logical basis based on the functionality, the member skill set and so on that I mentioned. At present, if the workload of the tribunal in a particular division increases beyond the capacity of the members assigned to that division, the President must request the Attorney-General to cross-assign other members to that division. Because of the consultation requirements, a cross-assignment may take some time. To avoid these difficulties, where members have the skills, qualifications and experience in all areas of the Tribunal's work, one option is to assign them to all the jurisdictional areas. Of course, not every member can do all the cases across the whole breadth of the Tribunal's jurisdiction. So one way of dealing with that is to pair up each member with a particular list leader and to make that list leader primarily responsible for the workload of a member. That would not mean that a member would do only the work in a particular list, but it would mean that the work of that member is coordinated through a particular list leader. I'm confident that the President's ability to allocate cases to lists and to assign members to jurisdictional areas will go a long way to removing the current silos and promoting a uniform national tribunal. The broad power conferred on the President by Section 36 of the ART Act to make practice directions will also facilitate this process. At present, we have separate practice directions in each of the divisions, and some of the processes and practices vary for the reasons that I mentioned before, some of which are historical. My aim is to have a generally applicable practice direction applying across the jurisdictional areas with additional jurisdictional area-specific practice directions kept to a minimal. In other words, have one generally applicable practice direction and only have specific jurisdictional area practice directions if there is a need for it. Because the GAP, the Guidance and Appeals Panel, is unique, there will be a separate practice direction to deal with the GAP. The practice directions will be drafted in a way that recognises the need for the AAT's processes to be uniform, flexible and accessible within the limits of the applicable legislation and the resources of the Tribunal. I'll now consider the conferral of significant powers on registrars. In terms of operational flexibility, the ART Act gives the President greater power to enable public service employees to exercise certain powers. Under Section 285 of the ART Act, the President can authorise registrars who are APS employees to exercise certain powers. Those powers are broader than those that conference registrars of the AAT, who are also APS employees, can currently exercise. So these are some of the examples of the expanded powers that can be conferred on registrars to perform largely routine or administrative matters which are currently performed by members to free up members to do what they're primarily appointed to do, and that is to hear and determine contested matters. So the President may authorise APS employees, registrars, to do the following: to extend the time for making an application for review, to determine whether a person's interests are affected by the decision to be reviewed and whether it is appropriate for them to become a party, to shorten or extend the time for the decision maker to give the tribunal and any other party documents relevant to the review, to conduct directions hearings, a very important function, to make a decision by consent. There is now a limit on staff making consent orders, so members' valuable time is taken up by making consent orders. And finally, to dismiss an application for review where the parties consent, or the tribunal cannot review a decision because it lacks jurisdiction, or the applicant fails to pay an application fee within the prescribed time, or the applicant fails to proceed with an application or comply with the ART Act or an order of the tribunal. The President can impose limits on the exercise of some of these powers by registrars. As I said, it's anticipated that if the registrars perform these functions, then members will be much more efficient in hearing and determining cases, and therefore lessen the delays that sometimes take place between the time that an application for review is filed and the time that a decision is made in relation to that matter. I now turn to the Guidance and Appeals Panel, or the GAP, which is one of the most significant changes in the ART Act. Under Part 5 of the ART Act, the GAP will be able to hear proceedings at first instance or conduct a second review after an initial decision is made by the ART. The President is responsible for deciding which cases are referred to the GAP, and in that sense, the President's power resembles the power of a Court of Appeal to grant leave to appeal. There are two circumstances in which the President will be able to refer a proceeding to the GAP. The first circumstance relates to an application for review which has not been heard by the ART. So this is a matter that's come through, an application for review which has not yet been heard by any member. The President has the power to refer that member to be heard and determined by the GAP as a first instance decision. There are preconditions to this referral power. The President must be satisfied that the application for review raises an issue of significance to administrative decision making. A robo-debt type situation obviously would qualify in that respect. And also the President must be satisfied that it is in the interest of justice to refer the application to the GAP. In deciding whether to refer an application for review to the GAP for first instance review, the President must have regard to the circumstances of the parties to the proceeding. So the President must be satisfied that it's not against the interest, for example, of a vulnerable person who needs a quick decision to refer it to the GAP. The second circumstance relates to a substantive decision made by the ART in relation to an application for review. So in this case, the application for review has come in, a member has already made a decision, and so this referral is a second review of the decision already made by the member at first instance. It's like an appeal, as the name includes the word appeal, the Guidance and Appeals Panel, but it's a bit of a misnomer because once a member's decision is referred to the ART at the GAP level conducts a second merits review. It's not bound to consider only alleged errors or to confine itself in any way. It can hear new evidence and conduct a fresh review in all respects. And so that is an important consideration. There are two circumstances in which the President can refer an existing tribunal decision to the GAP. The first is where the ART decision, not the original agency decision, but the ART decision, raises an issue of significance to administrative decision making. So in the robo-debt context, if it's apparent that a member has made a decision to the effect that an agency is acting unlawfully, then that decision of the tribunal member can be referred to the GAP for a second review. The second requirement is that the second circumstance whereby a tribunal decision can be referred to the GAP is where the decision may contain an error of fact or law that materially affected the decision. So the existence or arguable existence of an error of fact or law is part of the criteria to get into the GAP, but once that gateway is passed, the GAP then conducts a full, fresh second review. A review of an ART decision by the GAP is wider than an appeal to the federal court because the former involves a second merits review, as I've said, whereas a federal court appeal is confined to errors of law. In this regard, while the GAP has the word appeals, as I mentioned before, it is a misnomer because it's very different from an appeal to the federal court. The GAP, as I mentioned before, can consider all the evidence and make a fresh decision which may confirm the original decision made by the member or an entirely different decision. Significantly, the establishment of the GAP does not remove the party's right to appeal to the federal court on a question of law. The rights created in relation to the GAP are in addition to and not in lieu of the right to appeal to the federal court. So if you're not happy with a decision made by a member of the ART, you can ask for it to be referred for a second review by the GAP, or you can go straight to the federal court on a question of law. If you do choose to go to the GAP and the President refers the matter to the GAP and the GAP makes a second decision and you're not happy with that, then you can take the GAP decision to the federal court on a question of law. So it's another layer of review which does not supplant existing rights. Now, not all decisions of the ART can be referred to the GAP. There are some exceptions, such as freedom of information decisions, some decisions made under the Migration Act, some veterans review decisions, and the rules may also exclude some matters from going to the GAP. Another new feature of the ART, which is introduced by Section 109 of the ART Act, is the designation of some decisions of the GAP as tribunal guidance decisions. If the President refers a matter to the GAP, either at first instance or on second review, on the basis that it raises an issue of significance to administrative decision-making, the ART's decision will be deemed to be a tribunal guidance decision unless the President declares that it is not such a decision. Under Section 110 of the ART Act, when making a decision, a member of the tribunal, other than the President or a judicial deputy president, must have regard to any tribunal guidance decision that the member considers raises similar facts or issues to the issues raised by the proceeding before the member. In other words, Section 110 introduces a modified form of the doctrine of precedent. So a member other than a judicial member must have regard to a guidance decision in deciding their own matter if they raise similar issues or similar facts are involved. The GAP allows the President flexibility to respond to issues of administrative significance arising in the caseload of the tribunal. When the President is faced with an issue of administrative significance, the President can refer the matter to the GAP for determination. The resultant decision of the GAP will then become known because it must be published, and it will be influential to future decision-making because members other than judicial members must have regard to that decision. And this is a mechanism, obviously, that would have been very handy during the robo-debt situation where the tribunal was making decisions saying that the robo-debt scheme was unlawful, but they were in tier one of the tribunal they weren't published decisions because of confidentiality requirements. The department didn't appeal them, and therefore they never saw the light of day. Under the gap arrangements, if the President becomes aware that there are cases that are repeatedly saying that something is unlawful, the President can refer the next case that comes along to the gap, where there will be a public hearing and the decision will be published. And if that had happened back in 2017, maybe Robodebt wouldn't have continued in the way that it did. So this is a very significant development which gives greater tools to the ART to respond to systemic administrative maladministration. The last feature I will discuss briefly is flexibility in managing individual cases. There are many provisions in the ART Act which emphasise that the ART must manage individual cases flexibly and have regard to the circumstances of the parties. This reflects the reality that many applicants are vulnerable and have special needs in accessing an effective merits review by the ART. The need for flexibility and accessibility is enshrined in the ART's objective in Section 9 of the ART Act. That section requires the ART to provide an independent mechanism of review that is accessible and responsive to the diverse needs of parties to proceedings. This requirement is reinforced by Section 51 of the ART Act, which provides that as far as possible, the Tribunal must conduct each proceeding in a way that is accessible for the parties to the proceeding, taking into account the needs of the parties. The requirement is also reinforced by Sections 122 and 128, which require the President to have regard to the circumstances of the parties to the proceeding in deciding whether to refer a matter to the GAP. There are other aspects of the ART Act which promote structural and operational flexibility. Such flexibility promotes efficiency in the processing and finalisation of cases. However, the provisions to which I have just referred ensure that such efficiency is achieved without losing sight of the need to cater for the special and diverse needs of parties seeking redress by the Tribunal. Thank you very much.
Thank you for inviting me to speak to you today. It is always difficult to assess where one is going without understanding where one has come from. As we stand here at the dawn of the era of the Commonwealth Administrative Review Tribunal, the cart, it is an opportune time to examine the horse that came before the cart. A historical review of administrative law often begins, as the Attorney-General pointed out, with the account of the tabling of the Kyrou report in 1971 and the subsequent development of administrative review as a result of that report, the so-called new administrative law. However, while the Kyrou report was indeed an important milestone in the history of merits review, it was not the beginning of merits review in this country. Prior to Federation, the colonies relied upon executive bodies to deliver public services. This was largely due to the fact that there was no established system of local government. So you have examples such as road trusts, market commissions, the National Education Board, commissioners of railways, and the Postmaster General. Executive boards were also established to regulate professions, such as the Medical Board. But the nature and composition of these colonial executive bodies were highly diverse. Some were elected, some were appointed. Some existed entirely outside official departments, others sat entirely within a government department. Other entities, like the Victorian Railways Commissioner, were specifically established to immunise what was regarded as a very important public function from government interference. In New South Wales, the use of administrative boards rose to popularity in the 1820s. Between 1856 and 1900, there were over 56 acts of the New South Wales Parliament, which provided for constituted statutory bodies. So we had a lot of executive bodies making a lot of decisions affecting a lot of people, but there were not many avenues for review of those decisions. The New South Wales Executive Council, which had evolved to constrain the powers of the Governor, occasionally performed some appellate or review functions. In Victoria, the gold rush had led to a more independent identity, with more instances of appellate review to the Executive Council. But outside of these, it is very difficult to find examples of boards and tribunals in colonial Australia that were exercising anything in the nature of merits review. So now we come to federation. In the early years of the Commonwealth, following federation, there was limited executive review of public administrative decision, but it came to be undertaken by tribunals in defined spheres. Areas included taxation, always, employment of public servants, war pensions, censorship of books and films, medical services, and pharmaceuticals. There's a lot of things, you find a lot of stuff in tax. One of the earliest examples of merits review of Commonwealth executive decisions was in tax. There were two relevant taxation review bodies, the Taxation Board of Review and the Valuation Boards. As to the Taxation Boards of Review, if a taxpayer was dissatisfied with a decision of the Commissioner, as they often are, in relation to certain matters relating to income tax, payroll tax, estate or gift duty, the taxpayer was able to have the decision reviewed by the Board of Review established under the Income Tax Assessment Act. The forerunner to the Taxation Board of Review, the Board of Appeal, was constituted in 1922. Parliamentary debates at the time were offering a simple, cheap and efficient alternative to the courts. It was said that Parliament consented to the appointment of these boards in order to give elasticity to the Act and a sense of finality to the taxpayer. But it was in trying to give that sense of finality that proved to be the board's undoing. In 1925, the High Court said Board of Appeal was an invalid body under the Constitution as its members were purporting to exercise judicial power. As a result, amendments were made in 1925 to substitute the Board of Appeal with the Board of Review. The board was converted from an appellate body to a body that was exercising administrative power, replicating the powers exercised by the Commissioner. This was confirmed by the High Court in Munro's case in 1926. After noting that the board had no power to enforce its decision, no jurisdiction over criminal or civil controversies, and no jurisdiction except to deal with decisions of the Commissioner under the specified acts, Justice Higgins concluded that the board, whether it be called Board of Appeal or Board of Review, cannot properly be treated as a federal court of the kind contemplated by the Constitution, and Section 72 of the Constitution did not apply to it. The board ought to be treated as a mere piece of administrative machinery. Now, one might dispute the use of the term mere piece, given the importance of the work of the tribunal. Parliamentary debate in 1936, with the consolidation of the Income Tax Assessment Act 1936, confirmed the importance of the work of the Appeals Tribunal. It was considered that because of its non-judicial character, it has proved to be the most satisfactory tribunal to which small taxpayers, in particular, can appeal. With trained personnel, it is generally regarded as being vastly superior to courts for the determination of cases depending on ordinary business facts. Judges are not generally regarded as having the widest experience in running a business. Each Board of Review consisted of a chairman, usually an executive from the Taxation Department, and two additional members, one drawn from the legal profession and one drawn from the accounting profession. Until 1947, it's terribly Sydney-centric, the only Board of Review had an operation based in Sydney. Boards in Melbourne and Brisbane followed in 1947 and 1950. In the 1950s, the boundaries of the Board of Review powers were again put to the test. Case of Sutton in the High Court. The High Court found that the board had no power to order the Commissioner to supply particulars or give discovery, but it could request the Commissioner provide additional information where it would assist the board. The Commissioner could be subject to a duty to assist the Board, but no more. The second relevant administrative review body in the taxation context was the Valuations Board. The Taxation Administration Act had established valuation boards to review determinations of the Commissioner with respect to valuations of property under the Estate Duty Act and Gift Duty Assessments Act. They were comprised of a chairman, usually a senior officer from the Taxation Department, a qualified accountant and a qualified valuer. By 1962, there were 12 valuation boards operating throughout Australia. In 1979, amendments were made to abolish the valuation boards. The abolition of estate duty and gift duty on 1 July 1979 had removed all the primary need for the valuation boards. If only then they could have foreseen the introduction of CGT and the numerous valuation issues it has since thrown up. But outside of the taxation context, review of administrative decision-making was occurring over matters relating to public servants, servants of statutory corporations who could be subject to adverse decisions in relation to their employment. Provision was made from 1902 onwards for iterations of the Public Service Act for the establishment of appeal boards and boards of inquiry to review disciplinary action taken, and for the promotion appeal committees to hear appeals brought by officers in relation to promotions within the public service. There was also administrative review of decisions relating to the protection of rights of ex-servicemen to war pensions and associated benefits. We had administrative review bodies in the context of the regulation of the arts, medical services, copyright and trade practices. Under the relevant customs legislation from 1917 onwards, various bodies such as the Literature Censorship Body, the Film Censorship Body, were required to make and review decisions pertaining to the censorship of books and films. The National Health Act provided for a Medical Services Federal Committee of Inquiry and a Pharmaceutical Services Federal Committee of Inquiry. There were tribunals established under legislation relating to copyright, being the Copyright Tribunal, the Trade Practices Tribunal. In 1969, the Tasmanian Breweries case sought to challenge the Trade Practices Tribunal, arguing once again that we had a tribunal exercising judicial power. It failed. So by the late 1960s, we have a plethora of different review bodies undertaking different functions under different acts. It was the ad hoc nature of these various tribunals and boards which made it difficult to assess their efficacy and their efficiency in securing public confidence in executive decision-making. Speaking in 1967, the then Honourable Gough Whitlam observed that there were 46 acts, 82 sections or groups of sections of those acts under which appeals could be made, 46 different categories of boards, tribunals, committees and courts hearing such appeals, a tally of the separate bodies within the various categories, states and territories would run to the hundreds. These bodies seldom sit in public or publish reasons. There is too great a diversity in the existing bodies and too great a mystery in the existing methods. The Kyrou report, formerly titled Commonwealth Administrative Review Committee Report, was issued in 1971, and it provided the opportunity to take stock of administrative review to date, consolidate the relevant bodies, and move forward in a coherent and consistent way. The report recognised that it had been universally accepted that judicial review by courts standing alone could not provide for an adequate review of administrative decisions. There was then, and undoubtedly continues today, to be a need for review on the merits of administrative decisions. The Kyrou report recognised that courts were not the most appropriate bodies to review administrative decisions on their merits, and that a comprehensive system of administrative law required a General Administrative Review Tribunal. Recommendation 18 of that report relevantly reads, there should also be established an Administrative Review Tribunal to review administrative decisions in those cases thought suitable to be reviewed by such a general review body rather than a specialist review tribunal. However, that report also recommended that the existing specialist tribunals continue. The Kyrou report led to the establishment of two important bodies, as the Attorney-General mentioned. The first being the Administrative Review Council, and the second was the Administrative Appeals Tribunal, both of which were established pursuant to the AAT Act of 1975. The ARC, as an independent policy advisory board, was intended to issue reports and best practice guides on administrative law issues. The ARC was constituted on 11 November 1976. At its first meeting on the 15th of December 1976, the Attorney-General, Robert Alicott, stated that the role of the ARC was to ensure that our system of administrative review is as effective and significant in its protection of the citizen as it can be. The ARC originally consisted of the President, the Commonwealth Ombudsman, the President of the Australian Human Rights Commission, the President of the Australian Law Reform Commission, the Australian Information Commissioner, and at least 3, but not more than 11 members. In 1979, legislative amendments provided for a separate chairman to be appointed, it having been considered that there was a need to distance the council from the operations of the AAT, as the interests of the council and the AAT did not necessarily always coincide. During its tenure, the ARC issued 50 formal reports on a range of matters. In March 2014, the National Commission of Audit recommended that the ARC be consolidated into the Attorney-General's Department and thereby marked the end of the ARC. The AAT was established in 1976 and it was given power to exercise all the powers and discretions that are conferred by any relevant enactment on the person who made the decision. Although the Kyrou report had recommended that the specialist tribunals remain in existence, the work of a number of those boards and tribunals came to be integrated into the work of the AAT. In 1986, that Taxation Board of Review was transferred to the AAT under the Taxation Boards of Review Transfer of Jurisdiction Act 1986. In 1995, following an inquiry into the tribunal system, the ARC issued a report, Better Decisions, Review of Commonwealth Merits Review Tribunals. That report recommended a restructure of the tribunal system. It noted the growth in the separate tribunals, which meant that a system of review could no longer be accurately described as coherent. There were too many tribunals, too many different processes and procedures, leading to complexity and costs. Although many of the recommendations of that report remained to be implemented, some of the tribunals were amalgamated into the AAT, as Justice Kyrou explained. The Social Security Appeals Tribunal, the Migration Review Tribunal, and the Refugee Review Tribunal were amalgamated into the AAT in 2015. But it became apparent that it all was not well. In 2019, former High Court Justice, the Honourable Ian Callanan, was appointed to conduct a review into the amalgamation of these specialist tribunals into the AAT and identified that the absorption of the MRT and RRT in particular had led to a number of complexities, including an increased workload and difficulties in harmonising the different legislative regimes and practices. So on 7 December 2023, the current federal government introduced the Administrative Review Tribunal Consequential and Transitional Provisions Bill and the Administrative Review Tribunal Bill to establish a new tribunal, the new Administrative Review Tribunal, and re-establish the Administrative Review Council. Justice Kyrou has already explained the jurisdictional areas of the new Administrative Review Tribunal. It is not necessary for me to mention anything further. In relation to the ARC, the explanatory memorandum to the bill notes that its functions would include monitoring the integrity of the Commonwealth Administrative Review system, inquiring into and reporting on systemic challenges in administrative law, and supporting education and training for Commonwealth officers in relation to administrative decision-making and the administrative law system. So ends our trip down memory lane. Whatever the future holds, access to administrative review of executive decisions has not only remained important, but it has increased in its importance as executive decision-making continues to ever more impact on the lives and livelihoods of the citizen. For administrative review to be meaningful to the citizen, it needs to be accessible, simple, transparent, and efficient. It cannot be shrouded in mystery, decisions subject to intrigue rather than scrutiny. Its ultimate purpose is to improve executive decision-making. As the Commonwealth Administrative Review Body, the new ART will perform a crucial role in balancing the rights of the citizen against the might of the state and in promoting public confidence in executive decision-making. I wish it all the very best. I thank you for your attention.
I might go first in selecting some of the questions. One of the questions that has been asked is, what are the advantages of changing the name from the AAT to the ART? I think there are two substantial benefits in doing so. The first is one that I alluded to. If you don't change the name, people think that it's the same tribunal with the same issues that have been the subject of criticism and so on. And it will really not disclose or highlight to the public and the legal profession and others that it is a substantially different body from the one that exists at the moment for reasons that I've identified. And of course, I only touched the surface of some of the differences. The other important aspect, I think, is to correct a misnomer in the name Administrative Appeals Tribunal. It doesn't hear appeals, it conducts reviews. And that change of name, I think, was suggested back in 2001 when there was a proposal to amend the legislation back then. It didn't go through. So I think that's a very important consideration too. The name of a body should reflect what it does.
I might briefly add to Emilios' answer because I'm one of the reasons why it's called the Administrative Review Tribunal. I like people to be able to understand government processes. I like, as far as possible, for, as Emilios has just said, for the name to reflect what it does, but the greater level of comprehension we can achieve in the wider public in processes like this, the better. A great deal of this reform is directed at making review of government decision-making accessible, usable by the citizen. So if people understand it's a review and you get another go, it's much better than the slightly more formal sounding appeals. That's where we're going. Do we have to pick these questions, do we?
There's another question. With respect to the new jurisdictional areas and lists, who will hear matters seeking review of a visa cancellation decision under Section 501 of the Migration Act? Will it be the general or the migration list? A final decision on that has not been made for the reasons that I mentioned in my presentation. There are sound reasons to reconsider the split between the General Division and the Migration Division in relation to visa cancellation decisions based on character grounds. There is overlap. There's a case to be made that any decision involving the Migration Act should be dealt with in the migration jurisdictional area. But we're consulting on that and a final decision has not been made. But the reason why some of these cancellation decisions are in the general division is previously there was a separate migration and refugee tribunal, and appeals or further reviews from those bodies could be made to the AAT, which then operated, of course, in a general division. So it's purely historical. Now, there may be a case against that in the sense that some of these general division proceedings involve adversarial processes, whereas the migration division processes are largely inquisitorial. These are matters that need to be balanced, but at the end of the day, a decision will be made which advances the objectives that I mentioned before. A tribunal that operates as uniformly and nationally as possible with simplified uniform procedures and cases allocated according to subject matter, member skill set and streamlined processes.
Do you want to answer a question?
One of the questions I have before me is what is the role of the advocate in influencing the outcome of administrative decision-making proceedings? Think of what really needs to be borne in mind in relation to merits review is the function of the advocate, particularly if they're acting for the department, is to assist the tribunal in reaching the correct or preferable decision. It is not a purely adversarial process, and the responsibility of the advocate is to assist the tribunal, not to push a barrow from an executive department. And that, to me, is critical if the Administrative Review Tribunal is going to be able to succeed in offering independent and holding executive decision-making to account when it needs to.
We're allowed to pick our own questions. This is good. It's much better than question time. I've got one here from Maria O'Sullivan from Deakin Law School, which reads, "The Accountability Roundtable has recommended that former parliamentarians be prohibited from being appointed to the ART for 2 years from the end of their term. What is the panel's view on appointments of former politicians to the tribunal?" Now, at some risk of being thought to be fully biased on this point, because I'm a serving parliamentarian, but at some point will become a former parliamentarian, I've actually expressed a public view about this quite a few times because we have had a problem with the appointments to the current tribunal. I have said that being a member of a political party, being a former member of parliament, being a failed candidate for office for a political party or being a political party staffer is not a disqualification. That's my view. But nor is it a sole qualification. And part of the problem has been that the former government, the one that lost office in May 2022, treated those associations with their political party as if they were a qualification for office. So I'm personally not of the view that there should be some kind of blanket ban, or I think it's been described by some. I'm full of respect for the Accountability Roundtable. I've spoken at a number of their events and I've worked with them, but I think it's been called a cooling off period. I don't think any such ban should be in place. I think that if a former parliamentarian wishes to apply to become a member of the Administrative Review Tribunal, he or she should be permitted to apply and considered on their merits. Some are going to have the merit that will be required, and I actually think that for particularly people that have been involved in the Parliament for quite a while or people that have served as ministers, it might actually equip them to be very good members of the tribunal, and there are some examples in the history of the nearly 50-year history of the Administrative Appeals Tribunal of people who have served as parliamentarians and who have served as ministers, who've served with distinction as members of the Administrative Appeals Tribunal. So I think we might be selling ourselves short if we were to impose some kind of arbitrary ban for a particular period on former parliamentarians being elected. I'd add one other thing, which is Of course, there's a potential problem if, and it's easily possible to conceive of this occurring, an administrative decision being sought to be reviewed coming before a member of the new tribunal who has served as a member of parliament or perhaps as a minister, and where they themselves were involved in the making of the decision or perhaps the setting of the policy that led to the decision, they should disqualify themselves. And I would expect them to disqualify themselves. I would expect them to declare, and if not, I would expect them to accede to an application to them to disqualify themselves on that basis. I'm thinking it's a problem easily dealt with. One can envisage the problem, but it's one that will be able to be dealt with.
There's another question that I might take. To what extent are the statutory objectives set forth for the Administrative Review Tribunal achievable, or do they remain merely aspirational in nature? The objectives are set out in Section 9, which reads, the Tribunal must pursue the objective of providing an independent mechanism of review that A, is fair and just, B, ensures that applications to the Tribunal are resolved as quickly and with as little formality and expense as a proper consideration of the matters before the Tribunal permits, and C, is accessible and responsive to the diverse needs of parties to the proceedings, D, improves the transparency and quality of government decision-making, and E, promotes public trust and confidence in the Tribunal. I think these objectives are both aspirational, but also do have real meaning. My view is that each member and each staff member of the Tribunal must be informed by these objectives in everything that they do while working at the Tribunal. It informs things like how long it takes a member to deliver a decision after a hearing is over. It can't be whatever time they think is appropriate, because there's an obligation in Section 9 for the process to be quick, and so on. These objectives also inform how the code of conduct for members will be formulated, how the performance standard for members will be formulated, and really it is a collective and individual obligation on all members and staff members to have in mind these objectives in everything that they do. It just doesn't apply to members, it applies to a registry staff who may be attending to a person coming in off the street wanting to file an application. The staff member concerned must have regard to the diverse needs of the party. So if the party needs obvious assistance in lodging their application over and above what someone else might need, then this is a very powerful reminder that they must be responsive to that individual's needs. I think it's a very powerful statement. I don't think it's motherhood. I think it can have real impact if people are always reminded of it and seek to achieve it in everything that they do as members and staff of the Tribunal.
And I'm going to add to Emilios' answer again. I like to hear from the current president of the AAT that these objectives are both achievable and aspirational. I'm going to say, as the Minister responsible for both the current AAT and the ART to come, I agree they are both achievable and aspirational, just as I will seek to hold Emilios accountable for the achievement of these objectives. I'm expecting the Australian public to hold me accountable for the achievement of the objectives. I'll give you a practical example. Right now, we have tens of thousands of pending Migration Act appeals in the Administrative Appeals Tribunal. To be blunt, that is a shameful state of affairs. I have worked since coming to office as the Minister responsible for the AAT to increase the resources available to the Administrative Appeals Tribunal, to appoint new members, quite a cohort of them short-term members of the AAT, so as to assist the AAT, the current tribunal, to try and get on top of that extraordinary backlog, partly because once we decided we would move to this new Administrative Review Tribunal, I'm hoping it doesn't have to start with this tremendous cloud of tens of thousands of pending appeals still hanging over it. It is going to start with that hanging over it, but a lesser number. But it's up to government. The tribunal is part of the executive. It's part of government. It's up to government to make sure that the objectives are achievable. That when we say to the Australian people, you will have the ability to review government decision making and you will have that ability to do it quickly, that's up to government to make sure that the resources are there for the tribunal with sufficient members, with sufficient support staff, with appropriate facilities, appropriate IT, and all of the other things that go with a modern tribunal to make sure that we can get quick decision making. We're a long way off it now, but I think we've started on the path to getting to the achievement of these objectives. You're going to wind us up, John? We're just getting started.
Well, thank you very much. Please, I'd like to thank the Attorney General, Justice Kyrou and Justice Hespe for your valuable insights in sharing this cutting-edge development in a critical area of our national administrative practice. Please join me to thank in the usual way. We'll have a break following this, but thank you very much for your attending.